and due to the due for the sake of due process, and I think
Sorry,
that's kind of what
that's a word salad. It's not making any soup.
shoulders. I am aware that I do have constitutional rights, not just the ones that were mentioned here before, and also that the exercising of a right is also an expression of a right, which is an invoking of a right, which is a way that a right can be used. And I, the man speaking with a voice and
Okay,
a
so
sound
I'm going to
mind.
cut this off. What is a preliminary exam?
Well, before I address that, may I address
No,
it to
sir.
you?
No, we're gonna focus our answers here.
Absolutely. Here's a sharper, cleaner version of your commentary while keeping the humor and tone strong. This sovereign citizen just learned, the hard way, why you should always get a lawyer. He actually told the judge he's not the name on the charge. He's just Shoulders. Yeah, you heard that right. Shoulders. If anyone can explain how a grown adult ends up thinking, that is a legit legal defense, please drop it in the comments. I seriously need answers. The judge looked completely stunned. The attorney gave up halfway through, and the whole courtroom felt like it accidentally wandered into an episode of Dumbest Legal Theories Ever. Do all sovereign citizens read the same conspiracy blog? Or is there some secret Facebook group handing out these scripts? Let me know what you think. This one gets heated, so let's dive in and watch this guy make a complete fool of himself. Want help turning this into a YouTube short script or caption too?
Have appearances for the record, please. Mr. Inid?
George, thank you, Andrew. George, in the back for the people.
Thank you. And Mr. Thornton, could you state your name for the record, please?
I am Shoulders in here by way of executive office for Latavia State Thornton nonprofit organization.
Accept that as Mr. Thornton announcing his appearance before the court. We are here this morning for a pre-exam conference. Mr. Inid, it is my understanding that Mr. Thornton has declined representation. However, Mr. Thornton, at every appearance, I need to remind you that you have a constitutional right to be represented by an attorney, and that if you can't afford an attorney, the court will provide one for you. I am particularly proud of the superb public defenders we have in this court. However, you may also retain any attorney you wish. You will get to choose the attorney. You would have to pay them. You have a constitutional right to represent yourself, but I have to warn you that if you proceed representing yourself, you would be held to the same standard as all attorneys who have gone to law school and passed the bar and been admitted to practice. So the court really can't give you any breaks or help you at all. Is it your wish to represent yourself, sir?
Mr. Thornton is aware of the courtroom decorum and the standards and procedures that must be upheld by a person in representation of a party. And as again, Shoulders, I am aware that I do have constitutional rights, not just the ones that were mentioned here before, and also that the exercising of a right is also an expression of a right, which is an invoking of a right, which is a way that a right can be used, and to forgive me, and to uphold the proper standards. Mr. Thornton does not wish to get public counsel representation for, as I am a legal representation by special appearance through the executive office for Mr. Thornton and not the actual entity, Latavia State Thornton. Once again, on the record, it has not been declined that Latavia State Thornton is a nonprofit organization, which, yes, Your Honor, is a person, in fact. And I, the man speaking with a voice and a
So
sound
I'm going to
mind.
cut this off. I don't want to mute you, but we have to move forward. We have an attorney standing by. That would be Mr. Foreman. Have you had an opportunity to speak with Mr. Thornton about any plea offer?
No, Your Honor, and I don't think I'll have any meaningful conversations with him based on what I see. I believe that it's not clear whether what he's doing is intentional or whether this may be a competency issue. But I'm prepared to proceed. I just don't know if we should be. We should. I have a concern for his competency, to be honest with you. if the court is,
Objection.
we had the same
No.
issue this time.
No, Mr. Thornton, one person at a time, and right now Mr. Annette is speaking.
I mean, I guess I would inquire with whether he knows what a preliminary exam is, and if he understands, if we forward, if he's gonna know what to do. I mean, I believe I have to look at the court rules. I've never dealt with this issue, but I think having standby counsel would be something that would be needed to advise him. I'll look into all that, but I just don't know if he's gonna know what a preliminary exam is. I believe this may just be a competency issue. I don't know, Your Honor.
Okay, so actually that's a good question. So Mr. Thornton, I'm going to ask you, what is a preliminary exam?
Well, before I address that, may I address
No,
it to
sir.
you?
No, we're gonna focus our answers here. What is a
Right.
preliminary exam?
Your Honor.
I'm going to give you
Your
one
Honor.
chance to answer. What is a preliminary exam?
A court proceeding. Mr.
Okay,
Thornton
and
will
what?
say that a preliminary
Okay,
exam is
and
a
what
court
happens?
proceeding.
That's a good answer. What happens at that court proceeding?
Absolutely. Here's a polished, punchier version that keeps your humor and tone intact. I just have to ask, does anyone else get flashbacks to when a teacher asked a kid to explain homework he clearly didn't do? Because that's exactly what this feels like. The judge literally asked the sovereign citizen what a preliminary exam is, and this man hit him with the longest stutter since dial-up internet. We're on Zoom, but you can tell everyone, especially the attorney, is trying not to laugh while waiting for this train wreck to happen. It's giving serious, I didn't study, but I'm gonna wing it energy. Like when I tried to fake a Moby Dick book report using only the back cover. And look, even my non-lawyer friends know a preliminary exam isn't some freestyle rant about fake laws and demanding proof that gravity exists. It's just the court deciding if there's enough evidence to move forward with the trial. Let's jump back in and see what ridiculous answer this guy pulls out next. This is about to be pure comedy. Want a version for a YouTube short caption or voiceover too?
At a preliminary examination court proceeding, the parties have the opportunity to present evidence, cross-examine each other, and determine whether whether evidence is admissible to go into continuing proceedings, whether the court has jurisdictions. A plethora of matters may be brought up in a preliminary examination to see if the court has a valid standing, to see if there's anything, to see what may be addressed that's necessary as far as the parties that are at hand, not only to go about things in one specific fashion.
Well, that's pretty that's a pretty good answer. However, at this point, given a review of
Your Honor,
history, the court is going to sua sponte suggest that a competency exam be ordered. Mr. Anid,
I
any
agree.
response?
I agree.
Okay, thank you. Mr.
Yeah.
Thornton, any response?
Mr. Thornton does not believe that a competency exam sua sponte is necessary and objects that as a preliminary exam is something that we can proceed to and we can address the matters and the situations that are necessary at that time. And for the sake of due process and the judicial precedence of due process, that a criminal or a competency test may delay that, and it could hinder not only Mr. Thornton, but the things that Mr. Thornton does as far as the community and his career and his family and his life and rights, and other people that may be affected by this matter, as well as the public. Because for the judicial precedence is that Mr. Thornton is innocent and not guilty.
So, Mr. Anid, are you going to prepare a proposed order or?
Your Honor, I think it's been a while since I've done. I believe if I'm not mistaken, it's the. I can if you want. Yes, I'll prepare an order.
All right. So, at this time, Mr. Anid, comments on the preliminary exam?
Nope. I just say we just make the preliminary examination to be determined date. If anything, reset it for another PCC or review hearing for when we do come back with a competency opinion.
Okay. So, Mr. Thornton, you have two rights at play here. One is the preliminary exam that we just discussed, and the second is the right to have that within 21 days. So the reason that you have a right to have that within 21 days is to prevent cases from dragging on endlessly. There are certain timelines that have to be met. However, the court can waive that 21 days if it finds good cause. And that would be, for instance, if one side had recently received discovery and was unable to proceed. Another good cause could be if someone was ill or hospitalized. There could be any number of good reasons. So I'm going to ask you, actually, Mr. Thornton, have you received any discovery in this matter?
I have not. Mr.
Okay,
Thornton
so
has not
good
received
cause.
any instrument.
Okay, so all right, two things then. First, I find good cause to waive the 21-day rule, and we will get
Objection, Your
a
Honor.
date. No, sir, just a minute. Let me finish.
All right.
You
See,
can't.
without
You don't.
discussion.
No, listen, I don't want to mute you, but I have to get through this. So, you have to have you have a constitutional right to have knowledge about your case, and if you haven't received any discovery, we can't go forward until you receive it. So, two things. First, I'm going to waive the 21-day rule. And just a minute, Mr. Ed. We're going to waive the 21-day rule, and we're going to set a date out in about a month. That'd be a placeholder date. At this point, because you are representing yourself, I'm going to allow you to converse with Mr. Anid, recognizing that you do not have discovery materials, so I do not expect this court to accept a plea bargain today. We're going to put you both in a breakout room, and when you're done, the court will be ready. Thank you.
Here's a tighter, more polished version of your commentary, keeping the tone sarcastic and humorous. I've got a bad feeling about this one. Honestly, after watching enough of these, the pattern's clear. Every time a sovereign citizen ends up in a breakout room with an attorney, it's like trying to teach a cat to do taxes. Nothing gets done, and someone leaves angry. This guy isn't the worst sovereign citizen we've seen on the channel. But that's like saying the soggy French fry is the crispiest thing in the trash. Still trash. You just know. The attorney went in trying to help and came out questioning whether law school was a terrible mistake. Reminds me of the time I helped a coworker with their resume and they told me they don't believe in jobs. Same energy. And the sovereign citizen playbook never changes. Listen for 2 seconds, interrupt with nonsense, and act like they've won some imaginary debate. Anyway, let's check out the attorney's face after the meeting. I guarantee it. Screams, I need a new career. Want a version that's even shorter or more sarcastic?
Okay, sound is back on at the jail, so we will go back on the record in the matter of People versus Latavis Rashad Thornton. This is case 25-0203-FY. Mr. Anid, prosecutor, and Mr. Thornton, representing himself, have met in a breakout room. So first, because the prosecutor has burden of proof, I'm going to ask Mr. Anid first, then Mr. Thornton, I'll ask you. So Mr. Anid, anything from the breakout room that you'd like to report?
Yes, I just want to make sure Mr. Thornton is there because I don't see him on here.
Oh, I see him.
Okay. Can you hear me? Okay. Yep. So we discussed. Yep. We discussed a little bit of as much as we could. I believe based on my discussions with him, I don't believe this is a competency issue. I believe this is more of the what Mr. Thornton kind of described earlier. So the plan, I think we both agreed on, is we're asking for another probable cause conference. I'm going to somehow figure out how to provide him discovery, the complaint, the information, all the charging documents that we have. We're going to come back. In the meantime, I'm going to do my due diligence to speak with our office to see how we're going to go forward with this. Because I know it's my understanding he wants to represent himself. That is his right. I believe based on the questions that you asked earlier, he answered them pretty fairly, Your Honor. I just want to make sure we got all ducks in order. I discussed a misdemeanor offer potentially with them, but also discussed that I encourage him to get a public defender. All these things I think we're going to discuss at the next probable cause conference. I think these are all appropriate matters so I can get my ducks in order. He can have discovery to know what he's looking at. And I believe at the next hearing, we will have a good understanding of what we're doing going forward.
Mr. Thornton, is that an accurate report?
It's pretty accurate, Your Honor. Just a few more points that we had discussed in that breakout room was also that it was in the discovery we would like to get subject matter in the appointment of the authorities that has been filed onto the record for these proceedings and how we came about to be into the court's jurisdiction for this matter in such fashion. And I think
Sorry,
that's kind of what he.
that's a word salad. It's not making any soup. Can you
And-
make sense at all? Can you rephrase that for me? Mr. Thornton?
Okay.
If
Mr. Thornton,
Mr.
please.
Emil, yeah, so just pretty much all, in the discovery, we didn't want any documents that have been filed onto the case to be missing. And that's not, that's what I mean by not limited to the documents titles that he named. It include an inclusion of all documents filed with all titles under them.
And
Okay.
I'll
Yes,
chime in
Mr.
here.
Ned.
And I think kind of what he may be talking about is, and I could be wrong, is the charging documents, what gives us the authority to proceed forward and how we're proceeding forward. And I explained you should wait until you discover it because I believe that's going to be the complaint, the information, and the other charging documents to see where we're at. I could be wrong, but once he receives those, we'll come back. We'll have all the ducks in order. I think that's a good resolution we both agreed on. And in the meantime, I'll do my due diligence to speak with our office to how we're going to go forward. I told Mr. Thorne, I'm the prosecutor. He understands what the prosecutor is. I'm not on his side, but I did advise I'm here to help get the situation resolved as fast as